Mr. Ogren.
Thank you, Your Honor. May it please the Court, James Arkwin, Assistant Attorney General, on behalf of the Commonwealth. This appeal arises from the Commonwealth's attempt to obtain a legal determination under the Tobacco Master Settlement Agreement that it diligently enforced its tobacco escrow statute, General Laws Chapter 94E. Now, General Laws Chapter 94E requires tobacco manufacturers that do not agree to join the MSA to make annual escrow deposits for the Commonwealth's benefit. The amount of the deposits are based on the number of cigarettes sold in the Commonwealth.
Excuse me, can you tell me something? Maybe I'm just, I didn't understand it. Is there one nationwide independent auditor or one for each state?
There is one national independent auditor that makes calculations for all of the states.
Price Waterhouse?
Currently, it is Price Waterhouse.
And there's one national arbitration panel, right?
No, there is no standing arbitration panel. The arbitration provision that's at issue here is set forth in MSA Section 11C. It provides for an ad hoc arbitration panel when a dispute that is subject to arbitration under those provisions arises.
Are the members of that panel all are former federal judges, or?
The way it operates is that if there's a dispute that's subject to arbitration under that provision, each side to the dispute would designate one of the potential arbitrators, and then the two arbitrators would then choose the third among a panel of retired federal judges.
Okay. Now, not to go too far afield, but something like 32 states have dealt with this issue, and 31 of them have set arbitration, and North Dakota is the only one that hasn't. Am I off base on that?
No, you're not off base on that, Your Honor. And respectfully, the reason I believe those decisions should not be followed are these. First, all of those decisions in the 30-some-odd other states that have compelled arbitration of this particular dispute all trace their reasoning back to earlier decisions in Connecticut and New York. And those are the same decisions that the trial court erroneously relied upon here.
So if York goes down the drain, the rest of them go down the drain.
I think that's exactly right.
But your adversary says that you're wrong in how you describe the New York and Connecticut cases.
Well, I think the problem with it, and this is a matter that confounded the Superior Court, is in how you frame the dispute. The precise dispute that was raised by the Commonwealth's motion was whether it diligently enforced General Laws Chapter 94E.
Well, if you're right about that, if you're right about Massachusetts courts being allowed to do that, then I take it before the auditor could calculate this figure, which will be used nationally for all the states. If you're right, all 32 states are entitled to litigate the question of whether or not they diligently enforce their statute in any individual year. Is that right?
What would happen under our view is that each state would retain its jurisdiction to determine state-specific issues.
So there would be a trial court hearing in each state that's potentially susceptible to appellate review. In each state, it could take anywhere from 5 to 10 years before a decision would come down. And so the auditor would have to wait for that period of time for all the states to resolve on an annual basis whether or not the state diligently enforced the statute before the funds could be dispersed to the different states in any year.
Well, but the countervailing, I mean, that assumes...
Is that the way it would play out?
Essentially, yes, except I would add one point. I think there has to be a good faith, bona fide dispute about each state's diligence. The problem here is that the defendants have painted with a very broad brush, made global accusations against all the states that they did not diligently enforce.
But haven't all those disputes been resolved in your favor and in favor of all the states because of the application of a presumption?
No, absolutely not, Your Honor. There has been, there again is a fundamental misconception in the Superior Court's reasoning. There has been no presumption of diligence. What the independent auditor has said was that it could not determine the diligent enforcement issue because it lacked the expertise or the authority to decide that very issue.
Have there been distributions made for years before 2003?
There has been no penalty applied to any state based on not diligence.
Have the states received money?
States have received the money, yes.
And so I take it somebody has resolved this question in each year as to the diligent enforcement of the states.
No, Your Honor. The parties entered into a settlement agreement with respect to disputes prior to 2003. This dispute concerns an alleged penalty provision based on a loss of market share in 2003, and the defendants are attempting to recoup what they claim is an overpayment from the payments that were due on April 17th of 2006. That's the precise dispute. The Commonwealth's position with respect to that alleged overpayment is there is no overpayment so long as we diligently enforce the statute, because under the plain language of the MSA, Section 11D, the Commonwealth is immune, absolutely and unconditionally, so long as it diligently enforced Chapter 94E. Now, that is a state-specific immunity question. There's no efficiency that would be gained by submitting this to a national panel of arbitration, because a national panel of arbitration would necessarily have to review each question on a state-specific basis. And I think that would subvert the very purpose of the state-specific immunity provision, because it would shift the focus away from Massachusetts law, away from the specific and individual enforcement decisions that the Attorney General and the Commissioner of Revenue made with respect to the enforcement situation.
Also, you wouldn't get national uniformity necessarily, because even though you have one national auditor, you have different panels of arbitrators, aren't I right? So the other side keeps arguing that you would have uniformity from the independent auditor, but the independent auditor says he can't decide it because it's beyond his expertise, meaning it has to go to arbitration if you lose. And you have different panels of arbitrators who could all decide differently.
And they would have to decide each state individually. So even if there could be one panel of arbitrators, which we do not believe is possible because the plain language of the arbitration
you can't
provision,
because everybody's got to agree. And
each
nobody's
side
gonna
must
agree
specify.
all over.
That's correct.
But
And each side to the dispute is the state that's accused of not diligently enforcing, which gets to pick one arbitrator. Massachusetts, for instance, because its diligent enforcement is based on Massachusetts law and what occurred here in Massachusetts, would likely pick an arbitrator who would be in close to Massachusetts, where all the witnesses and the evidence exists, and someone who's familiar with Massachusetts law. Other states would do the same. So there wouldn't be the same arbitration panel. But more importantly, as Your Honor points out.
But it would be quicker and cleaner to go to arbitration, would it not? Because my brother has alluded to this. Arbitration, once the result comes in, is virtually unassailable, correct?
Yes, it is.
You're going to have experienced arbitrators in the sense that they're former federal judges, so...
But that would change the parties' agreement, respectfully, Your Honor, because what 11C provides is that the only matters that are subject to arbitration are those where the independent auditor, the accounting firm, has made a determination or performed a calculation. There is no independent auditor calculation or determination of diligent enforcement, and there never will be, because the independent auditor has consistently...
Well, can we go over the language of 11C? It says, any dispute, controversy, or claim arising out of or relating to.
Calculations.
Arising to what? It goes on to specifically say
Calculations performed by or determinations made by the
independent auditor. And the diligent enforcement determination is a question about how responsible state officials enforce the state statute. It looks at the conduct of the state in determining what measures of enforcement it deemed appropriate, given the resources of the state and given the particular circumstances in the state that were necessary to comply with Massachusetts law and to carry out the intent of the statute.
Doesn't 11C, however, refer back directly or indirectly to Roman numeral 9J? Which talks about the non-participating adjustment and diligent enforcement.
It does, Your Honor.
So
but Section
that
9J...
kind of suck in or draw in that into 11C?
I don't believe it does, Your Honor, because 9J is consistent with the independent auditor's primary function, which is defined in Section 11A, which is to calculate and determine the amount of settlement payments and to collect the information necessary for that. What 9J does is set forth a very detailed step-by-step instructions to the independent auditor as to how it is to go about making those calculations or determinations. But its language specifically says, with regard to the sixth step, which is where the penalty provision or the NPM adjustment provision is, that adjustment shall apply only pursuant to Sections 9D1 and 9D2. Now, 9D1 contains the two national conditions that apply equally to all states, the market share loss provision and the significant factor determination. 9D2, however, contains the state-specific immunity provision. And everyone agrees that if a state is held to have diligently enforced its escrow statute, it is immune absolutely and unconditionally from any penalty provision. And
I'm sorry, immune immune? In other
Cannot be
words,
subject to the penalty.
is it a penalty or an adjustment?
It is a penalty. The entire purpose of Section 9D is to penalize those states that do
So
not
it's called
diligently
the
enforce.
NPM adjustment? Isn't it an adjustment?
Well, it's an adjustment, it's a reduction.
Isn't that what it's called, an adjustment?
It is
the
called-
NPM adjustment?
In the form of the calculations that are performed by the independent auditors.
No,
Yes.
follow me. It's called an adjustment.
It
It's
is
the
called an
NPM
adjustment.
adjustment. And in the arbitration clause, it says, any dispute concerning the operation or application of any of the adjustments. What?
I
How
believe-
can it be clearer?
Well, because Your Honor is relying
It's
on.
whether the NPM adjustment applies, and if it does, in what amount, right?
I don't believe you are, Your Honor. Two reasons. First, the plain language of the language you're citing is contained in a parenthetical.
Yeah,
that's
including
modified by
not
the main
limited to the
clause.
following kinds of disputes.
Including but not limited to, and it's precisely modified by the primary language of Section 11C, which requires that the independent auditor perform a calculation or make a determination. There is no independent auditor calculation or determination of diligent enforcement, and there never will be one.
Any matter relating to, you're in agreement that the auditor must make a calculation.
When it has all the information,
And
yes,
here
it
it says
must.
it doesn't have all the information, it can't make a calculation.
Here it's saying there's no, yes, it can't make the calculation until the diligent enforcement determination is made.
So isn't that a matter arising out of, or excuse me, a matter relating to
The most that-
independent auditor calculations and determinations?
The most that can be said, and this is where the Superior Court, this is the actual dispute that the Superior Court decided, but was not the dispute that the Commonwealth presented, is that that provisional determination by the independent auditor that until the diligent enforcement issue was decided by the trier of fact, it would not penalize any state. And that particular dispute, however, even if that were arbitrable, as the Superior Court believed, and as the courts in Connecticut and New York held, the only question that would be presented for the arbitration panel to resolve is whether the independent auditor was correct.
Well, okay, let's say the independent auditor made a determination that Massachusetts hadn't fully enforced the statute and therefore made an adjustment.
Well, if the
So
independent
is that
auditor...
arbitrable, or is that...
No, well, the provisional determination about the calculation might be arbitrable, but the independent auditor doesn't have the authority to make the diligent enforcement determination. So we would be
But
right
it's
back here.
necessary to the calculation.
But it just like any other input that's gathered from any other source, the independent auditor, for instance, the other provision of this penalty provision is the significant factor determination, which is also provided in Section 9D, and it's also referenced in the parenthetical because it is part and parcel of this adjustment or
I'm
this
trying to
penalty
understand, are
provision.
you saying because the independent auditor said he couldn't or she couldn't or it couldn't make this calculation, that it's
Make
not
this-
arbitrable?
It's not the calculation, Your
It's
Honor.
the determination.
The independent auditor did make a calculation. It just didn't make the diligent enforcement determination. And because it didn't and couldn't make the diligent enforcement determination, the diligent enforcement determination is not subject to review by an arbitration panel. What may be subject to review...
So, my question is simply this. If the independent auditor had determined, had made the calculation, and so the adjustment is going to apply, the adjustment's going to apply. And Massachusetts said, whoa, wait a second. We really enforced the law. The adjustment shouldn't apply. Is that arbitrable, or is that, I mean, what do we do with that?
There would be an arbitrary dispute about the calculation, just as here, if the independent auditor did not apply the penalty, if it had applied the penalty, that dispute would be arbitrable. But what wouldn't be arbitrable is...
In the arbitration, wouldn't that the issue be, if whether or not the adjustment was made, wouldn't the issue be the same issue we're talking about here? Whether the state had vigorously enforced the law such that the calculation should or shouldn't apply?
But the independent auditor doesn't have the authority to make the determination of diligent enforcement, and it never has purported to make that determination.
Well, if he does have, if we were to say that he does have, or she does have the authority to make that calculation, or, I'm sorry, that determination of diligent enforcement, would it be arbitrable?
We would still be here for the purpose of the calculation dispute probably would be arbitrable because that was a calculation or determination made by the...
Just the question of the determination...
The determination of diligent enforcement calls for, we'd say, an interpretation and construction of the MSA, its language and its terms. And that kind of construction and interpretation of the agreement is expressly reserved to the MSA court.
Okay, but if we were to say, as all these other states have said, that the auditor can make the determination as to diligent enforcement, would it be arbitrable under the agreement?
If this court determined that it lacked the jurisdiction to make the diligent enforcement determination, then we would have no other choice, but that would have to be arbitrable.
But the other side couldn't say, no, it's not an arbitrable decision. It's the decision of the auditor is final. The tobacco companies couldn't argue that, could they?
Once it goes to arbitration, the decision of the arbitrator is final. But the question here is the input.
The auditor.
Is the decision of the auditor final?
No, the decision of the auditor is not final. Either side can, if it's an arbitrable dispute, it can either go to arbitration, or if it's a legal dispute, it should come to the MSA court.
Okay.
The issue here is the Commonwealth's enforcement of a statute. It requires a legal interpretation and construction of the MSA. And the Superior Court retained exclusive jurisdiction to resolve that dispute. The defendants have never presented any evidence contesting the Commonwealth's showing of diligence on this record, and the Superior Court erred in deferring to an accounting firm to make this determination.
Can I just ask you a question, Mr.
Why would they have to make a showing? The only question before the court was whether it was arbitral or not. Whether it had to be arbitrary.
There still has to be a good faith basis. I mean, the effect of what they've done is withheld millions of dollars from the Commonwealth based on the contention that the Commonwealth did not uphold its end of the bargain. The Commonwealth
Mr. Arquin, can I just ask you a question about that? I heard you say, and I heard Justice Cordy say, implicit was that the independent auditor had said that he or she could not determine whether or not there had been a diligent enforcement of state law, which seems perfectly reasonable. Where would I find that?
There are three places in the record, Your Honor, where the independent auditor has declined to make that determination. It's at page 908 of the record appendix, where the independent auditor determines that that no possible penalty could be applied to any state because each state had model escrow statutes in effect and had represented them to be in full force and effect. Also at page 1105, where the independent auditor expressly said that it is not charged with the responsibility under the MSA, nor qualified to make the legal determination as to whether any state diligently enforced its statute. And finally, at record appendix 922, where the independent auditor said it would not modify its current approach of not applying any potential penalty.
Could you just give me the first page reference again?
The first page reference was 908.
So as I understand your argument, one of the factors that goes into a determination of how much money the Commonwealth receives, whether or not one calls that a post hoc reconciliation or adjustment or penalty or whatever it is, the Commonwealth loses money. That is based on what must be a finding that there has not been diligent enforcement of a state law. Am I correct, yes or no?
That is correct.
Second, we have an independent auditor who has said, I am not qualified to make that determination. Is that correct?
That is correct.
And that means that if the independent auditor is not qualified or says that he or she is not qualified, we have the basis of a calculation which the Commonwealth says is untrue, but unless somebody looks at that, cannot be challenged in the arbitration, correct?
I think the only thing that could be challenged would be the provisional decision of the independent auditor that in the absence of any diligent enforcement determination, it would not penalize the states. But there could be no independent arbitrator review of the diligent enforcement determination itself because, as Your Honor noted, that determination or calculation was never performed by the independent auditor.
I have one last question, maybe not the last question. When the independent auditor makes a determination and that goes to arbitration, I'm not asking you what goes to arbitration, that determination of the independent auditor goes to arbitration. And if it is a state's position that one reason why the calculation of an independent auditor should be set aside by the arbitration panel is because there has been no factual determination that a state, the Commonwealth in this case, did not diligently enforce, why is that question unreviewable by the arbitration panel? You with me?
Well, if the situation were different and the independent auditor performed a calculation that penalized the states and it actually made a determination.
No, I'm saying he or she, the independent auditor has not made a determination, right?
If the independent auditor has not made a determination, then there is no arbitrable dispute. Because the plain language of Section 11C requires specifically that the only disputes that are subject to arbitration are those relating to or arising from a calculation performed by or determination made by.
Okay.
If there's no calculation or determination made by the independent auditor, there is no arbitrable dispute for the arbitration panel to review. The
Is your
arbitration-
But here, no, can I just ask the question differently? Here we have a decision, correct, that here we have a decision that there has been a reduction in the amount of money that the Commonwealth can obtain for under the settlement agreement, the master settlement agreement, correct?
Well, not by the independent auditor, by defendants through their self-help mechanisms.
Okay.
The independent auditor has calculated the full payment is due. The dispute that gave rise to the Commonwealth's motion was the self-help remedy that the defendants
I'm with
engaged in
you.
by withholding that money because they unilaterally claimed that they were entitled to the penalty because they claimed the Commonwealth failed to diligently enforce Chapter 94E. And again, they presented no evidence. And I think
Is your argument essentially this, that the independent auditor has to determine a formula, just very broadly, has to determine a formula, but one part of the formula or equation is missing, and he can't make that determination because that part of the formula must be made by a court because that depends on a legal conclusion. That's essentially your argument.
Yes.
There's a missing piece of the formula.
Yes. And
we
what we're
can't
seeking
put
in
it
the
in
trial
there.
court, and continue to seek, is a judicial determination of diligent enforcement and thus our immunity as a matter of law from this penalty provision. The different dispute that the trial court focused on and what the trial courts in 32 other states focused on was what the independent auditor does in this middle period where there is no diligent enforcement determination. It's got to make a calculation or determination. It chose, and it has chosen for the past several years, not to penalize the states absent a determination of diligent enforcement.
Of course, you could have written the settlement agreement a little more clearly. I mean, so that
Well, certainly the settlement agreement was written, it's a multiple state agreement among many sophisticated parties, but the core of it is this. I mean, the diligent enforcement provision is a state-specific immunity provision. It calls for a mixed question of law and fact. It is directly focused on the law of each individual state under MSA Section 18N, and it is dependent on the discretionary prosecutorial decisions made by individual state officers.
But
the Commonwealth.
Go ahead.
Well, I was going to just point out that the Commonwealth agreed to that provision because it retained control over its enforcement decisions. It is responsible for diligently enforcing Chapter 94E based on its own circumstances and its own decisions, not what happens in any other state. And if the Commonwealth establishes its immunity under Chapter 94E, it's immune without regard to whatever happens in any other state.
And you're saying that the calculation, the NPM calculation, under, I think, what was it, 9J,
9D.
that cannot be made without a determination of
No,
diligent enforcement?
the independent auditor is not going to make it.
Well, the independent auditor won't make it until the diligent enforcement. What it said is, I need the information from the trier of fact. And if, in fact, the trier of fact, say Massachusetts, goes back to its...
But why does he need that information to make the calculation?
Because-
It either turns the switch on or off, doesn't it? The diligent enforcement, you're either immune from the calculation or you're subject to it.
That's right.
So the auditor is capable of making the NPM calculation in
But it
Massachusetts.
couldn't be determined with finality until the diligent enforcement issue. Because if a state doesn't diligently enforce, what you have is the two market share conditions and significant factor determinations are determined for all states. There is a potential penalty available, but it can't be allocated or distributed among the various individual states until the immunity issue is resolved with finality in each state.
Mr. Ogwin, I know you've been answering questions, so I'm not cutting you off. I'm cutting my colleagues off.
I
unless
have one more
anybody has-
question, Chief
Okay.
Justice, please. At the end of the day, though, the tobacco companies are challenging the independent auditor's calculation. Isn't that correct?
They may be, but that's not the dispute that the Commonwealth raised. The
But he
Commonwealth's
didn't make a
diligent...
calculation. There's no number.
That's
There's
correct.
no number.
The Commonwealth's
No,
diligent...
the auditor made a calculation.
It did, but the Commonwealth is not challenging that calculation or
No.
determination.
Philip Morris is challenging it.
Well, that may be-
Any challenge about the calculation is subject to arbitration.
Well, and as I've pointed out, that particular dispute about this provisional decision by the independent auditor to not recognize the penalty until the diligent enforcement determination is made may in fact be arbitrable. But that is not the same dispute that the Commonwealth raised. The Commonwealth's looking to get to the end of the day whether or not we're immune from this penalty provision. And that determination it cannot be made by an accounting firm.
Okay.
It's supposed to be made by the judges in each individual state.
So the NPM calculation is not individual to Massachusetts. It is a number that applies across the country.
It has a combination of factors, Your Honor, 3 factors precisely.
Yeah.
The market share there has to be a national market share loss of a specified percentage, and it must be shown on a national basis that market share loss was that the MSA was a significant factor in causing that market share loss.
But it's
Those are the national
It's a
factors.
national figure.
It is a national figure, but it can't be allocated to any individual state
Okay.
unless the state did not diligently enforce. And in terms of diligent enforcement, each state is judged on its own merit,
Yep.
under its own laws, based on its own decisions. And Massachusetts has presented overwhelming evidence showing that it diligently enforced Chapter 94E in the relevant time period. And in fact, the sales of NPM cigarettes that are subject to these escrow provisions have declined by 99.5%. There has been, the entire purpose of this penalty provision is to penalize those states who do not take effective action to neutralize.
So why are you afraid of an arbitration?
It's
What's
not a
the-
question of being afraid of the arbitration. What we seek to determine is that this dispute goes to the conduct of state officials and the prosecutorial decisions they make in enforcing a state statute. It is at the core of the Commonwealth's sovereign interest. The parties' agreement requires that these types of legal disputes be decided by the MSA court in each jurisdiction. If the Commonwealth just basically was ordered to arbitrate this dispute, it could be potentially ordered to arbitrate every dispute that affects a payment calculation under the MSA, and it would divest the Superior Court of its continuing and exclusive jurisdiction over the MSA in Massachusetts. And that is not what the plain language of the judgment and consent decree required, and it is not what is within the plain language of MSA Section 7. And it would be contrary to the public interest and the public right for the court to so rule. The
Thank you,
judgment
Mr.
of the order of the Superior Court should accordingly be reversed. Thank you, Your Honor.
Thank you, Mr. Hoffman. Mr. Patton?
Thank you,
You
Ms.
have-
Chief Justice. May it please the Court, my name's Steve Patton. I represent R.J. Reynolds, and I'm arguing on behalf of the OPMs. I want to focus on the language of the agreement, because you heard on at least 3 occasions that language paraphrased as being limited to appeals from a calculation or a determination. That's not what the contract provides. It is a broadly worded clause that covers any, quote, any dispute arising out of or relating to calculations performed by or determinations made by the independent auditor. It's not an appeal mechanism. It's not limited to appeals from specific determinations that the auditor has made. That's not what the language says. Their interpretation, the Commonwealth's interpretation, would read that broad arising out of or relating to language excuse me, from the contract. These were sophisticated parties. If you look at the jurisprudence, including this Court's own jurisprudence, courts have uniformly held that those are words of art arising out of or relating to that are, quote, the paradigm of a broad arbitration clause, quote, the broadest language the parties can use, close quote. We cite those cases. They don't even purport to overcome that here today. They would read that language out of the contract. Now, if there were any question about this language here, and we submit there isn't, it would be eliminated by the including without limitation clause, which says, including without limitation any dispute concerning any of the adjustments, and it continues on, or allocations, and it continues on described in Section 9J. Now, let's look at 9J. 9J is a mandatory provision which sets forth 13 specific steps that the independent auditor has to perform each and every year. The language is mandatory. The payments pursuant to this agreement shall be calculated as follows. That's the first sentence of 9J. Of those 13 steps, if you look at the 6th step, it specifically says the independent auditor has to decide the applicability of the NPM adjustment pursuant to 9D1 and 9D2. What's 9D2? 9D2 is a diligent enforcement exemption. So it's not 34 or 35 or 31 of 32. I think it's now 36 of 37. North Dakota is the only other contrary state. I argued in the Supreme Court there last week. There was no intermediate appellate court.
Can I just ask you this? With respect to, as I understand it, and the briefs are excellent, but when you come at this firsthand, you have to kind of find your way through.
Sure.
The independent auditor, as I understand it, said that there can be no possible NPM adjustment applicable to any state that had an S-clause statute in full force and effect, absent an adverse determination on diligent enforcement by the appropriate trier of the fact. Now, I'm reading from the Commonwealth's reply brief, but do you agree with that characterization?
I do, but I very strongly disagree with the history that puts that into context.
No. So
yes.
then I simply had a question. To the extent that it's relevant, and it may not be,
Yes.
Who is the appropriate trier of fact, as that term is used by the independent auditor? Not who do you say is the appropriate trier of fact, but was the auditor saying, I'm going to make these calculations, and unless I've got some determination made, as it were, prior to that there hasn't been diligent enforcement, I'm just going to go ahead and use the default principle? Or was the independent auditor saying, I'm going ahead and using the default principle, and if you disagree with it, go fight it out with the arbitration?
It's clearly saying the latter.
The independent auditor is clearly saying the latter.
The independent auditor is clearly saying the latter. And I want to respond forcefully to this assertion that my brother at the bar repeated here today, that the independent auditor says it doesn't have authority or expertise. That was a preliminary calculation. You can find that at 1105 of the joint appendix. But if we objected to that and said that's not what the MSA provides and it's not our position, and if you look at the final calculation last year on March 29th, and you compare that with the preliminary, the 3 sentences that he cited to you, again without disclosing what the auditor ultimately did, were deleted. And that's what the record.
What the Attorney General says that. But the
Can I just get a page reference?
922, Joint
okay.
Appendix 922, and that's why the Connecticut Supreme Court just a few months ago dismissed this very argument and said that's not what they did.
But the Attorney General argues that the elimination of those words is just because they were unnecessary to the final decision, and that every decision he makes doesn't repeat all the language in the prior one.
I know they say that, and that totally ignores the history of how it came to be that those 3 sentences were deleted. But more fundamentally, Justice Cowan, what the independent auditor says is not dispositive here, even if they had it's what the language of the contract says, and the contract says on the auditor's authority 2 things. 11A broadly defines the authority of the independent auditor to make all calculations and determinations relating to payments. And we quote that language, including all of the adjustments and the offsets and the credits and the allocations necessary there too. Now, when the parties intended to create an exception to that very broad grant of authority to the independent auditor, they did so expressly. In fact, the exception that the Commonwealth cites really proves the point. In the case of the significant factor determination, they said we're going to have an independent economic consulting firm decide that, and its decision shall be final and non-appealable. Again, a nationwide decision maker, but the point being, where there was an exception, they said so.
Did you folks unilaterally withhold the payments?
No, we didn't, Your Honor.
You put them into escrow, didn't you?
Yeah, and that's, I think, corrected in the briefs. And again, they were paid into a disputed payments account pursuant to 11F7 and 8, which is uncontroverted.
You went by the agreement on how to do this.
Yes.
If a dispute arises about enforcement.
Yes, and that's Citibank, and there's a specific procedure. It's undisputed. That's why, of all of the states that have challenged this, the only one that has purported to challenge the quote, withholding has been the Commonwealth.
Have you
It's not true.
given us the sites to these additional cases that
Yes.
take it over 32?
Yes, you brought
Yes.
them yesterday.
We did. We filed some supplement, I think we
Yesterday.
filed a couple of supplemental authorities.
You talk about nationwide enforcement, uniform enforcement.
Yes.
But if there's a panel of arbitrators that's different in every state or
No.
in many states,
No, Your Honor, and
why
I'm...
isn't it going to be different if each state can name one of the arbitrators?
Because of the language of the contract, Section 11C doesn't say that each party gets to select an arbitrator as to each issue. The language says each side to the dispute. Now, the dispute here is much broader than whether Massachusetts diligently enforced. All the states claim, hey, we diligently enforce.
No, but the facts are going to be different in each state, just what the Attorney General and the DOR did in each state, or the equivalent.
Yes,
It's
Your
going to be
Honor.
different in each state, so the facts are different in each state.
I was addressing the question of one panel. It's going to be up to that one panel how they go about their business of hearing individual cases. But Your Honor is right that if, after there's discovery in this nationwide arbitration panel, if the Commonwealth is a state that's still in dispute, yes, its specific facts concerning its enforcement will be heard by that one nationwide panel. But why every court to consider this has held that it's one panel, not 52, is because the language says each side to the dispute. I mean, if the Commonwealth were right, we have a plethora of other issues. Who bears the burden of proof? Can there be a presumption? All of those issues, there'd have to be a separate panel for
Mr.
each
Patton,
issue.
Help me with this. I'm sitting representing the Commonwealth, okay, and I'm wary of the settlement agreement, and I'm negotiating the settlement agreement. And I say, you know, there are going to be huge, quote, adjustments, penalties, whatever you want to call them. I'm going to lose tons of money because the first thing they're going to do is come in and say, we're not diligently enforcing, because there were, as you know, obviously there are companies that didn't sign on to this, and you're not going to be footing the bill for that. Your client's not going to be footing the bill for the people who are getting away with, not complying. Okay. And the Commonwealth says, and we do it differently here in Massachusetts. I don't know what they're going to be doing in Virginia. I don't know what they're going to be doing in North Dakota. But I don't want to get stuck with some national panel that's going to be looking at endless discovery of 50 states when they come in and say no state is diligently enforcing. So the first question I have to you is, with respect to the money that is held appropriately in the escrow agreement, how many states does your client claim is not diligently enforcing?
Well, at this point, we are challenging and disputing diligent enforcement in all states, but we fully expect that after there's all we have are allegations at this point
No, I understand.
by the states.
And
but after there's
you've
disclosure...
just told me about discovery, right?
Yes,
So
that group will be...
I've got one little state. Let me just take, I may be, I'm sitting in Massachusetts, and I think, great, we're doing not me, the judge, but the Attorney General. I'm diligently enforcing. And I'm doing it because I'm complying with this good faith, what I'm supposed to do under the contract. And now, all of a sudden, I'm involved in discovery with respect to diligent enforcement of 50 different states. I've got to go to all those depositions because I never know what's going to be held, and all of this and I'm going to get bound up with all those other states out there who are not doing diligent enforcement. Why would I give up my immunity if I thought I was buying onto that?
I'll tell you why the Commonwealth and the other states did, and this was pretty, I think, fundamental to the agreement. This reallocation provision, that's something that they want. There's no dispute about this. Those states that don't diligently enforce bear the entire brunt of this. Now, why would that be something states would want? Because the only manufacturers that play by the rules in this agreement, abide by all these marketing,
Sure.
but that pay. Let me put it this way. The states have lost billions of dollars already from the shift in market share from a fraction of 1% to something like 8% now, minus 2 is the 6% we're arguing about here, to NPMs. They don't pay anything under this. So the states agreed to a regime where to incentivize it. Well, it's not a penalty. The penalty is not used any place. This is an adjustment, but it is an incentive if you impose similar financial burdens on the NPMs, the non-players, and you diligently enforce that. Now, why is Commonwealth? Because if I diligently enforce, All these payments are on a nationwide basis. They're based on nationwide volumes. To the extent that market share shifts from participating manufacturers to non-participating manufacturers, the pie shrinks, my share gets smaller.
No, that's why
I want to make sure Idaho, by golly, diligently enforces. So the reallocation, and this goes to, I think, Justice Graney's question earlier, or I guess it was Justice Cordy's, what do you have to fear from arbitration if, in fact, the Commonwealth's enforcement record is...
Well, that's not the way we ask the question. We ask the question is, what did we agree to submit to arbitration? Right?
Yes.
So it's not a question of fear. It's just, what did we agree to submit to arbitration?
But I was answering Your Honor's question, which I thought was more practical. Sure. What they agreed to was plain. This language applies here, and you've heard no argument that would provide any basis for not doing what 37 and 38 other courts. But
before you sit down...
Yes, Your Honor.
Could you give us some sense of... We know $30 million's at play, if that's the right word, in Massachusetts. You're contesting this throughout the country, correct?
Yes.
How many dollars are we talking about?
The nationwide adjustment is $1.1 billion for 2003.
And that's in escrow someplace now?
Well, a portion of it is. Some of the companies disputed it but went ahead and paid. About $600 million or $700 million of that is in escrow in Citibank. But the total...
Earning good interest?
Yes, and whoever prevails ultimately gets the interest on it. I mean, it's getting prevailing rates of interest for that.
Mr. Patton, that may benefit some next governor. It's not going to benefit this governor. But may I ask you one other question? Let's assume that there's a determination that Massachusetts and Idaho and Virginia have diligently enforced, but the other 47, I don't know if the Tellesley's in here as well, have not. What's the impact on Massachusetts when you talked about the adjustment and the incentive to make sure that everybody diligently enforces?
I'm sorry, I missed. Is Massachusetts an enforcer or
an enforcer? An enforcer.
An enforcer.
They get everything.
Yes. Then I agree with my colleague that they would be entitled to an exemption, a safe harbor for that year. Their share would not be. Now, that doesn't mean it comes out of the escrow account, as we explain it in our brief. And I don't want to overcomplicate it, but it's really a matter of reallocation among the states. See, if the OPMs prevail as to any one state on diligent enforcement, they're entitled to a portion of that money in escrow back. If they prevail on diligent enforcement as to states with a allocable share of 18% or more, right, they get all of it back. That could be as few as 2 states. That could be New York and California.
And you telling me that the Commonwealth gave up its immunity when that was boy, that stacks the odds against one state, doesn't it?
I'm not sure.
Where are they going to get the money from?
Where are they going to get? Oh, from the reallocation of the next payment among the states. Those states that did not diligently enforce will have to give up some of their share of that next payment to those that did. And the
30 million plus interest?
I'm sorry?
30 million plus interest?
Yes, 30 million plus interest for this state and for all the others, 4 or 5, or if there were, 30 of them. But the bottom line on the practicality is that if Commonwealth or any other state is as a diligent enforcer as they claim, they probably won't even be subject to the kind of further proceedings you're talking about, but they certainly have nothing to fear from being part of this nationwide process.
If, on the other hand, if they get caught into some massive discovery, endless litigation, and so on and so forth.
Well, it's what the agreement requires, number one, and that's a controlling thing. But practically, I disagree with that because the discoveries to them will be directed toward them. There may be discovery as to several states. It may be that at that point there's a sufficient showing or that they're not even, as the Delaware Chancellor, described it in response to similar kinds of arguments. Come on. Realistically, what's going to happen is that the group will be narrowed down as there's more disclosure of information. But if Massachusetts or some other state is not a diligent enforcer, I've described this reallocation provision before as a game of musical chairs where there's multiple states that could be left standing. But whoever's left standing bears the brunt of the entire adjustment. So if, in fact, their record is not as pristine as they claim, and I'm not saying that it's not, it very well may be, then they have every incentive to be part of a nation.
If it very well may be, right? What you're saying to me is you've tossed them into a whole dispute when, in fact, you've got no basis of saying they haven't diligently enforced.
Your Honor, that, all due respect, misunderstands how this agreement works. If you look at 9D2,
right,
If you look at 9D2A, which is a provision they never addressed, the presumption is that as here, the NPM adjustment shall apply. There are two requirements, market share loss and significant factor. Look at 91, it says where those two prerequisites are met, the adjustment shall apply. You look to 9D2 for allocation. 9D2A states the general rule that the adjustment shall apply to the allocable share of all states. 9D2B is the exception, and the burden is on the state to establish that it qualifies for the safe harbor. They have the evidence, they have the showing. So now, all I'm saying is a practical matter. It may not require a complete adjudication of their case in front of the Nationwide Arbitration Panel for them to satisfy that exemption. But the point is, if in fact they were a state that did not diligently enforce, then they will benefit from a nationwide arbitration to make sure that everybody is subjected to the same uniform standard. If we have, as the New Hampshire judge said, a race to the bottom, then that hurts everybody.
Well, who has the burden of proof on the question of diligent enforcement if the auditor hears the case?
It would be the states. We contend under the agreement, but I want to make clear that's a disputed issue that's going to have to be decided by arbitration as well. I don't purport to say that Mr. Argan would.
Whereas if it takes place in state court, the burden of proof is on the tobacco company.
The agreement doesn't provide for being a state court, but no, I don't think that's true. I mean, if the state court, if one were to rewrite or disregard the arbitration clause and put this in the MSA court, then it should be the same contract that the state court judge would apply. One other thing, though, about that, Justice Spina, is Section 7, which is the only provision they rely on affirmatively here, expressly accepts this dispute from the authority of MSA courts in not one but in three separate ways. First of all, and I think this they even concede, it says that any dispute that's arbitrable under this broad arbitration provision is not within the purview or the jurisdiction of the MSA court. Secondly, and I don't think they really address this, any dispute relating to Section 9D. Well, what's 9D? 9D is the NPM adjustment and the diligent enforcement exemption. But if there were any question about the matter, if you look at 7A and 7C, the language, it specifically limits the jurisdiction of each of these 52 MSA courts to disputes arising within or relating to just that particular state. This dispute does not do that, and there's no dispute about that because of the reallocation provision. So when one of you mentioned before, well, geez, wouldn't there be, I think it was you, Justice Spina, wouldn't there be 52 separate proceedings, and somebody else said it would take years for those to work through the appeals? Yes, and compound that with the complexity that would result from a state who fears that it might not have diligently enforced having to intervene, which is the state's response. Well, how do you protect the rights of the other stakeholders, the other states, because a decision as to MSA will affect all 51? Well, they can intervene.
And now, Mr. Patton,
way over your time.
Thank you, Your Honor.
And Mr. Brookhiser, that doesn't mean to say you've lost your 3 minutes, but would you like to use them or not? And I'll see if we can jointly keep you to 3 minutes.
I'll welcome that, Your Honor. May it please the Court, my name is Bob Brookhiser, and I'm here representing two subsequent participating manufacturers, Commonwealth Brands and Liggett Group, who joined in the OPM's motion below to enforce the arbitration clause of the MSA and fully support the decision below. Subsequent participating manufacturers are, with one exception, companies that were never sued by any state, yet voluntarily signed the master settlement agreement and agreed to the really substantial financial obligations, $4 a carton. One of my clients, although not a huge company, paid over $200 million, not quite $200 million last year, even though it had never been sued. These companies generally compete on the basis of price. The NPM adjustment provision is critical because that is the provision, as Mr. Patton said, which provides incentives for states to equalize the playing field or try to equalize the playing field between those companies that joined the MSA and those that didn't, by requiring those companies to adopt these escrow statutes and diligently enforce them or be subject to the NPM adjustment. The arbitration provision, and particularly arbitration of this NPM adjustment, is also very important to the subsequent participating manufacturers because as relatively smaller companies, frankly, we don't have the resources to go around the country and litigate the issues of diligent enforcement and all of the other issues relating to that NPM adjustment as the state's position would have. At the end of the day, though, this is a contract issue. What does the agreement provide? And in real estate, it's location, location, location. Here, I think it's language, language, language. And I want to hit the parenthetical clause, which the state, although it was a part of the Judge Blow's decision, the parenthetical clause, the state completely ignored it in their opening brief, and that couldn't be clearer, as all of the courts have found. It covers disputes. This dispute, because it relates to the application and operation of one of the adjustments, the NPM adjustments, and its allocation. Even the North Dakota court, the only one that went against us, recognized that the natural and ordinary meaning of that clause was what we said, that it applied here. And it had to go and apply an inapplicable rule of construction, ad justum generis, and then misapply it in order to find otherwise. What that court said and what the state says here is that, well, no, this isn't a clause that provides examples of arbitrable disputes. Only some of the disputes in the parenthetical clause are arbitrable. But that's not what it says. This is a subset of the larger group. And whether you might have some issues of how far that part of the agreement goes, there's no question but that this dispute is covered in the parenthetical.
And now your time really is up.
Okay.
And I'm not going to let anybody ask you a question. We have a lot of people. Thank you, Mr. Brookhiser.